say, Steve?
Yeah, Michael, we're waiting for a couple people to use the correct link. Welcome to the Federalist Society Missouri. Today's webinar is brought to you by the Federalist Society's Regulatory Transparency Project and practice groups. My name is Steve Schaefer, and I'm the director of the Regulatory Transparency Project. We are happy to host a stellar panel of experts to discuss this important case. Note, the opinions expressed are those of the experts. Today's moderator is Brent Skorup, who is fellow at the Center for Constitutional Studies at the Cato Institute. Brent previously was a senior research fellow at the Mercatus Center at George Mason University, where he researched free speech, technology law, the Fourth Amendment, regulation, and property rights. We are also proud that Brent is a member of the Regulatory Transparencies Project Emerging Tech Working Group. Brent, over to you.
Yeah, thanks, Steve. I want to thank Federalist Society for hosting this conversation. The Murthy case is as Justice Alito said in dissent, one of the biggest free speech cases the Supreme Court has taken up in a while, and it's great to see a lot of interest in it. So I'll introduce the panelists, and then we'll go to discussion. In alphabetical order, Corbin Barthold is TechFreedom's Internet Policy Counsel and Director of Appellate Litigation. He received his JD from UC Berkeley School of Law. He clerked for the Honorable Stephen D. Merriday at the Middle District of Florida and the Honorable Robert H. Cleland in the Eastern District of Michigan. After his clerkships, Corbin was an associate and later partner at the Los Angeles office of Brown George Ross LLP, and he has since joined the public interest law world, and we're glad he has. Josh Devine is Solicitor General of Missouri, where he oversees the office's appellate and special litigation divisions. He received his JD from Yale Law School, and he clerked for Supreme Court, first 11th Circuit Judge William Pryor, and then at the Supreme Court for Justice Thomas. Before serving as Solicitor General, he was Chief Counsel to U.S. Senator Josh Hawley. And finally, Jenin Younes is Litigation Counsel for the New Civil Liberties Alliance. She holds a JD from NYU School of Law. She spent the first part of her career as an appellate public defender in New York City, including arguing several cases before the New York State Court of Appeals. And so I'd like to go first to Jenin and provide the audience, viewers, listeners who perhaps weren't aware of the Murthy case before last week, but follow the Supreme Court and have an interest in free speech issues. You and NCLA represented a few clients in this case, and so if take a few minutes, please cover the facts in this case, your clients, as well as the district court and Fifth Circuit decisions in the case.
Thank you so much for having me. Well, I might need more than a few minutes, so I'll be as concise as possible.
Yeah, no, take time.
So we represented 4 individual plaintiffs. Probably the 2 most people know are Jay Bhattacharya and Martin Kulldorff, who were co-authors of the Great Barrington Declaration, which was a declaration that eschewed lockdowns, basically saying that they were more harmful to society than they were helpful. And they're epidemiologists at Harvard and Stanford. We also represented Aaron Cariotti, a psychiatrist who declined to get the COVID vaccine because he had natural immunity and lost his professorship as a result, and Jill Hines, a health freedom worker in Louisiana. And their core allegation was that they were censored on social media, but not essentially because of the platform's content moderation policies, but because the government had inserted itself into COVID-related censorship. Now, I also want to clarify, there's another plaintiff in the case, Jim Hoft, who we didn't represent, who was alleging government interference with his speech that was more about the 2020 election and the Hunter Biden laptop, since the government was also involved in trying to get those topics suppressed on social media. So the facts in this case, it was a 20,000-page record, even though this was just up on appeal from a preliminary injunction. So it's hard to summarize them briefly. But essentially, the White House, various agencies such as the CDC, the Cybersecurity and Infrastructure Security Agency, which is housed within DHS, the FBI had in various ways tried to influence the companies in order to censor disfavored speech. When it came to the White House, there was often a lot of coercion going on. There were direct threats, private and public, to try to repeal Section 230's protections, which, as most people know, the companies rely on in order to not have to be held liable for what people say on their platforms, which the platforms need in order to function as social media, where people can just post whenever they want. Also, there were threats to look at antitrust provisions, and the platforms had reason to fear that the administration was actually going to do this. Some of the conduct was more collaborative. For instance, when it came to the CDC, Facebook and other social media companies were kind of working in tandem with the government, saying, like, we're going to take these kind of posts down. The CDC would send examples of posts that should be taken down, flagging, so-called vaccine misinformation, mask misinformation, that kind of thing. I think it's really important to point out that although the First Amendment protects, so-called misinformation, even false speech, our plaintiffs were not saying things that were false. They were saying mostly true things. I would say perhaps almost entirely true things. And Jay Bhattacharya and Martin Kulldorff are two of the top epidemiologists in the world, and they were being censored at the behest of the Biden administration on topics, on the areas of their expertise. So I think this case really highlights why we have a First Amendment and why we don't allow the government to be involved in this kind of thing, or in suppressing viewpoints that it disagrees with. So the core allegations, some additional allegations were raised in the complaint, but the core, especially on the preliminary injunction, the core complaint was First Amendment violations. And the idea was that the government was sort of instrumentalizing these private companies to accomplish its censorship aims, and that was effectively a First Amendment violation because the government can't use private industry to accomplish what it can't directly. So the district court in the Western District of Louisiana found for us almost entirely, found that the plaintiffs had standing, and found that that it was, well, this was on a preliminary injunction, but that the government had likely violated their First Amendment rights and that the harm was irreparable. So granted the preliminary injunction. It was mostly upheld by the Fifth Circuit. The Fifth Circuit kicked out a couple of the defendants. So they found there wasn't enough evidence that NIAID, NIH, so mostly we're talking about Dr. Fauci, that he was actually involved in this censorship. So he was not in the injunction. Importantly, also, the district court denied the government's motion to dismiss the complaint. So the case in the district court is still live, despite the fact that the Supreme Court reversed the grant of the preliminary injunction.
Yeah, thank you for that. Yeah, apologies. A little housekeeping. First of all, it's great. We have, two people who represented parties in this case, which is great. And I want to thank Solicitor General Devine for taking time out of a busy schedule, I'm sure, for coming. We should have time for audience questions as well. So as panelists are speaking, feel free to offer some questions, and I'll ask those some of those at the end. Next, I'd like to turn to Corbin and ask for an assessment of the district court and Fifth Circuit opinions. I know I listened to podcasts from you, and why I reached out to you. You had some good reservations about the nature of the injunction, the breadth of the injunction, and I think you may have had issues with the standing as well. So, and obviously the Supreme Court, found the standing issues to be most salient here. So Corbin, for you, your assessment of the district court, Fifth Circuit opinion, and also the Supreme Court opinion, just how they came down, how they did.
Sure. Okay. So as with the first question, is that there's a lot there.
Yep.
It was pretty clear to me how things were probably going to go with the rest of the case from July 4th, 2023. That's the day the district court issued its opinion. The district court took what it called a bird's eye view of traceability. And so it kind of glossed over the actual record. Didn't really make an attempt to link any government conduct with any specific act of content moderation. More importantly, though, the court presented a factual analysis that was so riddled with errors and fabrications that it was clearly going to be useless to any reviewing court. Also, the judge bought into the censorship industrial complex narrative, in which the Stanford Internet Observatory was supposedly a puppet of the government through CISA, instead of a group doing its own independent research and advocacy, and let's not forget, exercising its own First Amendment rights. So those problems trickled up to the Supreme Court. The government had to say in a footnote in its reply that it couldn't possibly respond to all the inaccuracies that were floating around, which was true. Justice Sotomayor said at oral argument that she couldn't untangle all the inaccuracies in the plaintiff's brief. She said, quote, I have such a problem with your brief, counselor. You omit information that changes the context of some of your claims. You attribute things to people who it didn't happen to, ... I don't know what to make of all this. And at the oral argument, the SG of Louisiana, I'm afraid he didn't really help matters. He kind of bounced around. The justices struggled to understand him. Justice Barrett said she wasn't even sure what his argument was. He said, I'm a First Amendment purist, and then he wasn't able to present the scope of the categories of unprotected speech correctly when talking with Justice Kagan. So the opinion didn't end up really being a surprise. At footnote 4, the justices, the majority, wrote, the Fifth Circuit relied on the district court's factual findings, many of which unfortunately appear to be clearly erroneous. And again, that's true. Throughout our discussion, it's important to remember that the district court sort of thoroughly botched the factual record here. The majority noted that neither the district court nor the Court of Appeals made any specific causation findings with respect to any discrete instances of content moderation. It noted that Justice Alito in dissent basically had to construct a theory of causation on his own. And the majority, for its part, basically just refused to do that. It trotted out the old line about how judges aren't pigs hunting for truffles in the record. So in the end, Justice Alito could formulate his dissent kind of only by boiling things down extensively. He bypassed almost all of the sort of gish gallop of facts and allegations that have been thrown around below. And so the censorship industrial complex stuff fell by the wayside. We didn't hear anything about sort of like significant encouragement or entanglement. He had to kind of construct for himself a Bantam Books analysis that was nothing like what the plaintiffs had presented at oral argument, where they'd argued that sort of any request by the government to take something down crosses the line. So while job owning is a really concerning issue, and I hope we can all kind of agree on that through the discussion, my take was this just wasn't really a good case to decide much of anything. Now, moving to the Supreme Court decisions, once the case got narrowed down to how the majority and the dissent framed things, I do think there's reasonable disagreement over the proper outcome. You had sort of this jousting with different Supreme Court standing decisions, and maybe we can get into that more. Justice Alito certainly had a point that the court should try to apply its standing doctrine consistently. But what you basically had was agreement, like at least at a high level, that the government exerted pressure on the platforms to moderate content related to COVID-19 in the 2020 election. But the majority said that it had to work, quote, to untangle the mass of the plaintiff's injuries and government communications. And once it did that, it just couldn't find any solid links. So, to give one example, we heard about the Great Barrington Declaration. But the majority found that the platforms had taken action against that before there was really any communication between the platforms and the government. So I think the ultimate take home is the majority wasn't willing to engage in sort of this imaginative reconstruction of the vast record that was plopped in a pile before it. That was kind of my biggest take home.
All right, thank you for that. Next, I'd like to turn to Solicitor General Devine. And if you could talk about, I guess, first of all, talk about Missouri's interest in the case for a bit. little unusual to see a state. I was glad to see Missouri take an interest in the case, but talk about the state's interests and also, I followed this case and there was, if you could also talk about some of the depositions and evidence, that turned up in this case, and then I'll probably follow up as well.
Yeah, so I'll take those in order. So Missouri's interest in this case, one of the theories of standing that we pressed is that there's this long line of cases from the by the Supreme Court that the Supreme Court doesn't really discuss very much in this opinion, which is that the states have an interest in hearing from their citizens. You've got a bunch of different cases, Terminiello, Garnieri, that all discuss that the whole part of the purpose of the First Amendment and part of the purpose of free speech is to enable states to really hear from their citizens so that they can be responsive to the needs and concerns of their citizens. So that's one of the theories of standing we advance here. And that's a definite state interest. The Supreme Court didn't deny that. Instead, what it said is that, you need to be a little bit more specific in the type of thing that you're wanting to hear. The problem, of course, is when things are being censored, nobody really knows what this universe is. That's the whole point. It's being censored, and so you don't know exactly what's going on. You don't exactly know what you're unable to hear at that point. And so the Supreme Court's kind of set up this impossible standard from the perspective of the listener's ability to identify the things that they would like to hear, but they're unable to. The second thing that the Supreme Court does is it pretty much ignores about 20 years of precedent with respect to the ability of states to bring what are called parens patriae lawsuits against the federal government. So you've got these cases from the 90s and early 2000s where the Supreme Court allows states to do that. And basically a parens patriae action just means you're in essence asserting you're asserting that there's a very widespread harm to the people of Missouri, to the people of the state. And what you're essentially doing is you're asserting that this harm has become so widespread that it has in fact become an injury to the state itself. And the Supreme Court allowed this in a 1995 case. The Supreme Court allowed this in a 2007 case. And what they did here is they dug up dicta from a 1960s case, and they said, and they just cite that and say, well, this is the states can't bring parens patriae suits against the federal government. But if you actually look at that, that's dealing with situations where the state isn't actually asserting its own kind of harm. It's purely asserting the third-party harms of other individuals. In every single case where a state has asserted its own theory of harm, the U.S. Supreme Court has allowed the state to bring a parens patriae action, and the Supreme Court just completely misses that entire line of doctrine, doesn't discuss it at all. And so I think we've got a very unusual parens patriae decision from the Supreme Court on this issue that really just doesn't wrestle with that fundamental difference and what gives the states the ability and the interest to bring a suit like this. I want to respond to a couple of things that Corbin said. I think we've got a large amount of no surprise that one of the individuals representing these plaintiffs disagrees with what Corbin said. Let me just leave it at this, which is that nobody really disputes at the Supreme Court. Nobody really disputes that there were very severe First Amendment violations that were going on. I mean, the majority opinion, for example, discusses at one point, like, yeah, it looks like that pressure from the federal government actually altered the policies of Facebook and Twitter and these other organizations. But then the Supreme Court says, but that's a past violation. You can't necessarily get prospective relief from that. But they don't deny that there were blatant violations. The government had insinuated itself into this atmosphere and had actually physically changed the policies of Facebook and other organizations to induce further future suppression. But I think just from a causation standpoint, if you look at the facts, if you look at what happened in July 2021, you see a rapid, much more aggressive posture from the White House, from the Surgeon General, from some of the other defendants in July 2021, much more aggressive. And then you find an uptick in censorship after that. So it's never been our position that there hasn't been some some censorship or suppression or content moderation or whatever term you want to use. It's never been our position that there hasn't been some of that already going on by the platforms. But what we identified are, you've got some of these discrete events, July 2021, huge increase in aggression from the White House. And then you also see an increase in content moderation or suppression or censorship. And it doesn't take a genius to be able to draw that inference there. Now, look, you can't draw a certainty inference there, but the doctrine doesn't require any kind of certainty. It requires a likelihood. And so, I do want to very strongly dispute the idea that we didn't establish causation, that we didn't do anything like that. I think the Supreme Court basically looked at the record and, refused to draw a single inference in our favor, which was different from the district court and different from the Court of Appeals.
Thank you. I'll ask a follow-up on that, just something that jumped out in the opinion, then I'll ask each of you for things that jumped out in the opinion and in oral arguments itself, but just following Solicitor General Devine's comment. So the majority's about traceability. The majority statement said, the primary weakness in this record, and this is a quote, in the record of past restrictions is the lack of specific causation findings with respect to any discrete instance of content moderation, end quote. So maybe Jenin, first to go to you. I'm not an expert on standing, frankly. That seems like a very high standard to establish standing, that you need to show in the First Amendment context specific causation findings with respect to any discrete instance of content moderation. Your response to that statement from the court?
Yeah, it seems to me that the court's basically requiring that you show that a specific post was censored because of the government, which seems very, very hard to do. And I'll use, so this was actually an example that came out later through a congressional investigation, but it's a very clear one. There were internal emails from Meta that were revealed as a result of this investigation, where Nick Clegg, who's an executive there, wrote to another employee and said, "Can you remind me why we censored the lab leak theory?" And the other employee says, "Because we were under pressure from the White House. We shouldn't have done it." Unfortunately, that was not part of the record because it was came out after the Fifth Circuit briefing. And there's a lot of stuff in the record that is very similar to that. That's just the most stark example. So I think it crystallizes it. But that is very clear that this entire theory, this entire narrative, this entire line of thought was censored on social media because of the government. And I think even there, the court is insinuating that you would have to show that your specific post was censored because the government had called you out or named you. I don't know who's going to be able to do that. There may be two people. I can think of RFK and Alex Berenson, who are specifically singled out by government officials by name. I also want to respond to, if I may, one thing that Corbin said about the factual inaccuracies. I really want to dispute that. This was a 20,000-page record. The district court might have gotten it said a couple of things not exactly the way I would have characterized them. There was one email from Rob Flaherty where Flaherty was using very colorful language to demand the takedown of I think a parody account of the president's granddaughter. And it wasn't about COVID misinformation, but we had actually not misrepresented that. And I think that was what was insinuated. We were showing it as part of a pattern of the government's treating these companies as sort of subservient. So I think the idea, I don't know what inaccuracies anyone's talking about. And if Corbin would like to elaborate, I'd be happy to respond. But I think that the lower courts were actually really understood the facts well. And I would say, I don't think the Supreme Court read the record. It was clear to me that the dissent had a much greater, a much better grasp of the facts. I guess, did I respond to your question?
Yeah, you did. And I'll with that, I'll turn to Corbin. Don't want to put you on the spot.
No, the last thing I want to do.
I also want you to, maybe I'm being hyperbolic. I want you to walk me off the ledge that this traceability standard, as I read it, it seems to say you've got to show, you've got to show the email where the government official said, take Brent Skorup's post down. And it seems like short of that, it's pretty difficult. But yeah, feel free to respond to anything that's been said.
Yeah, I mean, the last thing I want to do is take up our whole hour with Jenin and me arguing the record. So, the 22 million tweets versus 4,000 is a problem. The fabricated quotes of Rene DiResta, of targeting domestic speakers, of the threat of, quote, legal consequences, what the press secretary never said. You have problems with talking about CISA and how the election integrity partnership was actually set up. You have problems with the word targeting being used. I would recommend people take a look at Stanford's amicus brief in the case where they get into this. And I'm sure Jenin probably has disagreements with what that brief says, but I think that brief and certainly footnote 4 speak for themselves. I don't think Justice Barrett would make that line lightly. Now, hopefully, to say some things that Jenin will agree with. I think what we ultimately need to land on is something between the broadest possible reading of the majority opinion and the dissent. Because at times the majority does, I mean, they never say this explicitly, but they make it sound like you need to be like named directly. And that just can't be the standard. I mean, that's highly problematic. They noted that the platforms had, independent incentives to moderate content. And I have thoughts on that, but like, I know this much, that cannot possibly be like a get out of jail free card. It can't be like, well, somewhere in the mix, we have an incentive. And so, plaintiffs lose. That can't be right. Josh, I think it's an interesting question whether the majority agrees that there was no violation. I mean, I don't think they ever say that explicitly. That's certainly not my read of the justices from the oral argument. But you're right. Like they don't come in on that. I think ultimately we have to kind of hope that like this opinion is not read broadly. Their decision was shaped in part, I think, by how it was litigated and adjudicated below. Vulo being a few months before, maybe we should take heart that like, these things are not, a lot is left to be fought over. And then the last thing I just want to insert, because I don't want to derail us, but I thought Josh's discussion was interesting. And I'm wondering if he has thoughts on whether maybe some of the conservative justices in the majority were like spooked by Massachusetts versus EPA, seeing like a decision that maybe all of us in the room would see as like a stretch of what states can bring in and sue on, and if that maybe derailed them. And the reason I bring that up in this answer is I think there just were a lot of hydraulic pressures on this case that might have shaped the majority opinion in ways that maybe they'll actually change course a bit in future decisions.
Well, so I've been thinking about this a lot, and there was a lot of coverage in the past 4 years since Justice Barrett was nominated of like, oh, this is the conservative court that's going to like roll back everybody's rights, blah, blah, blah. And like that's what you're getting from the cottage industry niche press that appears to just criticize the Supreme Court 24 hours a day, right? Like that's the kind of coverage you're getting. And in fact, what you get instead is a group of justices who have, for their entire legal upbringing, been very, very, very skeptical of standing. And so, I mean, that's what you've seen this year and last year and the year before is just really just ratcheting up the standing requirements in case after case after case. So Mass v. EPA, pretty much most conservatives disagreed with that opinion, thought it was far beyond the outer reaches of standing. And so it almost looks like they're kind of trying to stealth overrule some of these opinions. Like I said, in the parents patriae context, like the Supreme Court is just absolutely wrong to cite that decision in Snap without recognizing that there are several different decisions after Snap that completely undermine that opinion with respect to parents patriae. Supreme Court's just entirely wrong, and they're ignoring that line of precedent there. But you look at that and then same thing with Department of Commerce. I think Justice Alito is right. I don't know how you can, the Department of Commerce was unanimous with respect to the standing question. New York could sue because there was a predictable effect that the census question or the citizenship question on the census was going to lead to reduced a reduced number of individuals filling out the census. Well, of course, it's a predictable effect that when you have this kind of government pressure, there is going to be censorship. And so I think I think it's a similar situation where the Supreme Court is kind of trying to cabin these other standing doctrines without saying so explicitly.
Yeah, I will say, I mean, some of the dicta in the majority decision was a little perplexing to me. I mean, for redressability, they point out like these COVID censorship efforts had diminished over time, but we have New York Times stories saying that this litigation is why a lot of the pressure has diminished. The fact that this was being litigated, they attribute it to the fact that there was a lot more scrutiny through this litigation.
Yeah. One thing on that. I mean, obviously, we would have preferred the win. Would have obviously preferred the injunction, and I think this case is going to be a big setback. I think some of the some federal officials are going to feel emboldened. They're going to have learned from their previous mistakes, and they're going to do things a little bit more subtly in the future. But we also exposed this. A couple of years ago, people didn't know that this was occurring. And then we brought this lawsuit. We got all this discovery that launched congressional investigations where they got, frankly, even, they got a lot of documents that we didn't get because our discovery was limited. And we exposed this this real apparatus of the federal government trying to pressure people to take down First Amendment protected speech. And, we can talk all day about causation. We can talk all day about, did the district courts get all the quotes right and things of that nature. I don't think anybody can really disagree that the federal government was way over its skis and was violating the First Amendment. Maybe we don't know who the exact persons who should be suing are over this, but the federal government was blatantly violating the First Amendment, and this lawsuit exposed that.
All right, thank you. And just a word of housekeeping. Steve, Michael, I haven't seen any audience questions yet. Perhaps audience hasn't asked any, but I don't know if there's a way to forward those to me if there are any, but I will move on to my next question. Speaking of Josh's, I guess this is for Jenin and Josh. Speaking of disclosure and kind of scrutiny this case generated, one thing that jumped out to me in following this case was the fact that the FBI in particular is using encrypted communications to make takedown requests to social media companies. Now, I believe most of this is so-called election disinformation or malign foreign malign misinformation. How much, and it came out in depositions, the FBI has stored all of these communications. How much of that has been turned over? How much of that has been revealed, or is this mostly unknown under some national security privilege or something?
I think, and Jenin, you might have had more involvement with the initial stages of discovery than I did, but our discovery, the court says we received extensive discovery. I mean, if you just look at the number of pages, I guess you could consider it extensive. But it's a drop in the bucket compared to everything that was going on. Essentially, what we were able to get is we got documents that are between the White House and platforms, between the CDC and the platforms. We got a lot of those documents, and then we were able to get a number of depositions based off of that. But there's all kinds of internal documents that we've never yet had access to through discovery. There's all kinds of documents internal with the social media companies that Congress has started to receive, but that we hadn't received. So I think there's still a whole lot more to be discovered in this situation. We only got a fairly limited amount of discovery for the limited purpose of the preliminary injunction stage.
Yeah, that's right. I don't have a whole lot to add. To be honest, I'm not sure about the FBI question since I was more focused on the COVID, and that's sort of a specific issue I wasn't paying that much attention to. But with respect to the question of what we got, I mean, it was very limited. And another thing to note is that we got third-party discovery on 5 of the major platforms. We were allowed to choose 5, and we chose Twitter, LinkedIn, Meta, of course, etc., YouTube. And what we found from those was that the government had actually not been honest about the extent of its involvement. So we found that there were officials and agencies that the government had not named in response to interrogatories, but that the platforms showed were or told us basically were involved in this. So I think that's another reason to be very wary of what's going on.
Yeah, I mean, Twitter X, when it undertook new leadership, frankly, they were a lot more forthcoming about what had happened. There were the Twitter files that they released, but also they gave us information saying like, oh, all these are individuals at Twitter who are communicating with individuals at the in the federal government, and their list was way longer than the list that the federal government gave us.
All right, thank you. So I see a couple questions from the audience. I'd like to ask this one before we turn to audience. I thought the plaintiffs here, I think they went about it the right way. They didn't try to make, bring in the social media companies, even though the record and kind of the history here is a little muddled. I mean, you do have this kind of two-way communications, government, social media, and social media government. But the litigation here was focused squarely on the government. But then the Supreme Court, I was somewhat alarmed on the standing issue. The Supreme Court seemed to say plaintiff standing could have been stronger had they brought in social media companies on this. From the majority decision, it says the plaintiff's theories depend on platforms' actions, yet the plaintiffs do not seek to enjoin the platforms in this case. And then it goes on to say it's a bedrock principle that federal court cannot redress injury that results from the independent action of a third party, not before the court. It just seems odd. I mean, it seems to be inviting to get standing. It seems, maybe I'm misreading it. Correct me if I'm misreading it. It seems to be saying you should have sort of sued social media companies as well, since there were government interacting with social media companies. I also just it's hard to square that with Vulo, which came out I think the day before. That NRA didn't have a standing issue, but they never sued the insurers or banks that cut them off from services. So I wonder if anyone can square the Vulo standing issue with what happened here, and also
I
almost on the court statement there.
I almost wonder if Vulo had gone up on a preliminary injunction, and if we had gone up on appealing a motion to dismiss, that it would have come out in opposite directions. I mean, because Vulo is on a motion to dismiss, the Supreme Court's drawing all the causation inferences in Vulo's favor, and because we're at the PI stage, the Supreme Court is drawing none of the inferences in our favor. And I think that really explains the major difference here. As far as suing the platforms, I don't. When I had the same reaction that you had at first, Brent, when I read that. But then reading the rest of the opinion, I don't think it really stands for that point. I think they were just using that to introduce the concept that the plaintiffs are going to have to distinguish acts by the platforms from acts by the federal government. And frankly, I think we did that. Again, you showed July 2021, much more aggressive rhetoric and outreach by the federal government, accompanied by an increase in content moderation by the social media companies. I think that's good enough inference. But that's what I understood the Supreme Court to be saying, is that because you're not suing the social media companies, you're going to have to be able to do something to disentangle their independent actions from the federal government's actions.
Can I say one quick thing on that? I kind of wonder if they thought that the companies should be suing. If the companies want to sue and say that their First Amendment rights were violated, and that would kind of square with the NetChoice decision, which I have not had a chance to read in detail, but where they seem to be saying that the platforms do have a First Amendment right to their own content moderation policies. So I sort of wonder if that's the lens through which they view it.
Yeah, I thought it was a little odd. On the Vulo Murthy thing, my take, which is as subjective as anyone's, but is that Vulo, whatever the government can do, they can't do what New York did in Vulo. So I think even if you had disagreement among the justices at oral argument here, they could all get around how the very explicit Justice Alito called it ham-handed in the Murthy case, stuff in Vulo So that's your backstop. I was puzzled by the fact that the government, when we got up here to the Supreme Court in Murthy, instead of saying, if we lose, the remedy is you tell us to knock it off, they said, if we lose, then maybe that makes the social media platforms these public forums that have to follow the First Amendment. And that seemed to be quite a bit of a brinkmanship on their part. And I wonder if this ties into that. Maybe Josh has thoughts on that. I'm speculating. And then the other thing I'll add, it might have been the majority sort of trying to throw Clapper back at Alito, because in Clapper, which Alito wrote, which is about the chain of causation of somebody saying, I want to talk to people in Europe, I think it was Europe, who might be surveilled under FISA Section 702. And Alito said, look, the chain of causation is too tenuous here. That decision says the court is, quote, reluctant to endorse standing theories that require guesswork as to how independent decision makers will exercise their judgment, and that the majority was hanging their hat on that. But I'm not sure either. I found that slightly puzzling.
All right, we've got a question from the audience. This is for Mr. Devine. Your former boss has been an advocate of Section 230 reform. I'm just reading the question. What are your thoughts on the use of Section 230 as both the carrot and the stick? Do you think Section 230 reform is necessary to prevent these actions from continuing or occurring again in the future? Maybe a clarification that the First Amendment trumps 230 immunity. Feel free to respond to any of that.
Yeah, I think Section 230 is interesting here. I'll preface my remarks by saying I have not read the net choice decision that came down, 2 hours ago, other than the few things I was able to get on Twitter. But I've always thought there's a little bit of a contradiction in the way that the platforms have presented some of these issues. On the one hand, in cases where liability is trying to be imposed on them, they run a Section 230 and they say this isn't our speech. And if you look at the definition of speech in Section 230, Section 230 is saying that the platforms aren't liable for anything that somebody else created. And the platforms cannot even have helped to develop it in part. So it has to be something that is completely somebody else's content. And so in that context, they go and say, hey, none of this is our speech. It's all speech from somebody else. So Section 230. And then you get to the net choice cases and they say, well, actually, we have a First Amendment right in, collating and deciding where we're going to put different speech. And that product is, in fact, our own speech. Even though we're helping to develop, at least in parts, everything that's coming to us, that product is our speech. And so you have these two different doctrines where the platforms have taken two inconsistent positions. And after today's net choice decision, I think we're going to see some further development in the Section 230 area. I think the case law on this has not really wrestled with the text very well. If you look going back to the early 1990s opinions, the Zarin decision from the Fourth Circuit, what you find are really a lot of purposivist points of analysis where they're saying, well, we have to interpret it this way because Congress had a policy if they wanted an open internet this or an open internet that, and they haven't really grappled with the text. And after the net choice decision today, I think there's going to be a lot more of that. I would not be surprised to see future courts take a look at Section 230 and interpret it more narrowly than previous courts have done in the past.
Yet another debate that we just shouldn't dive into. I happen to think Zarin is a fine decision, but surprise, surprise, Josh and I have our disagreements there.
So next question I'd like to pose. Well, yeah, I mean, it's probably, as you can probably tell, I was a little disappointed with this decision. I mean, it doesn't seem to help people who might have a plausible argument that they've been swept up in some censorship effort as I read the case, and that was like reaction to it. Yeah, on one side, there seems to be Bantam Books and NRA v. Vulo, where if you're singled out specifically by a government official, you can probably get a foot in the courtroom and probably even win a First Amendment lawsuit. But it seems if it's a whole of government censorship approach about topics and not people, and particularly if you don't keep many records of it, it's going to be very, very hard for a plaintiff to even get their foot in the door, much less win. And it's disappointing to me because this is how government censorship has worked for a century. They're typically wise enough not to single out individual parties and ask a newspaper or broadcaster to censor somebody. It is typically topics, and is typically conveyed via private meetings. And the Supreme Court seemed to have blessed this century-long censorship effort. Do others see it that way, or do you disagree with how I framed it?
I think that the thing that is strangest to me about this case is if you had a statute, let's say Congress passed a statute that says, we think that COVID misinformation is a really serious problem, and so we authorize the president to browbeat and jawbone social media companies into suppressing this information. If you had that statute on the books, there would be no dispute that Bhattacharya and others could have brought a pre-enforcement challenge to this statute. There would be no dispute over that. And so it's strange to me that and you could do that even if there is no evidence that the federal government had actually taken any kind of enforcement action yet under this statute. You'd be able to do that. And so where we have the reverse situation where it's worse because Congress you don't even have any kind of semblance of democratic legitimacy. You don't have a statute, and the Supreme Court or the federal government is doing it anyway, and somehow we don't have standing there. I think this is.
Wait, Josh, do you think Clapper would get in the way there?
I think in the original situation, if you have a statute on the books that says you can do this, then anybody at risk of censorship would easily meet the Susan B. Anthony list against Dryhouse situation. I'm at risk of censorship. I can challenge the validity of the statute, and then you would get a declaration that the federal government's not allowed to do this thing. But because there is no statute, yet the federal government's doing it anyway, it's somehow ironically harder to challenge it. That's the thing that just doesn't make any sense to me right now. And I share your concerns, Brent. And I think, I know our team is huddled together thinking about the ways that we're going to move this case forward. Again, as Jenin said, we won at the motion to dismiss stage. So we're going to be able to go down and get some discovery. The Supreme Court's decision was only about standing with respect to the PI, said we don't have enough on this record. Well, I look forward to going back and delving a lot deeper in the record and finding more.
Yeah, Brent, what I think it really points up is how desperately we need transparency in this area. If Biden says they're killing people in public, everybody sees it. We all, it's kind of what happened with the Disinformation Governance Board. That was a public announcement and there was an outcry and they quickly shuttered it. And people get angry about how that happened and all, but sort of all's fair in love and war. It's out in public. We have a debate and then whatever, democracy works. Whereas if it's happening in secret and, you don't know, I think that's what you're concerned about, right? I mean, so it would be nice if a new administration by executive order or Congress, people could get their act together and say, the social media platforms, or the government or somebody has to keep a log of these things, any request, any contact or whatever, and play it out that way.
Yeah, I mean there is such an act. I think the House either just passed or it's pending in the House, like the Transparency Act, and I am obviously a big proponent of that. But I thought the dissent put it very well that as long as what the message that this case sends is that, or this decision sends, is that if the government carries out this campaign with enough sophistication and under the cover of darkness, it can get away with it. And I don't think that's a good thing for the American people. And the only reason we know about a lot of this is because of the discovery in this lawsuit, as well as the Twitter files and a few FOIA requests that the government actually complied with. So, yeah, I think that highlights the importance of continuing to fight this battle, though.
So we'll conclude. We got only a couple minutes left. So in 30, 45 seconds, just final thoughts about the case, something you haven't said, or something that stood out in this litigation as it's already been indicated. This doesn't seem to be over. I mean, for one, as already mentioned, RFK Jr. almost certainly has standing. He was singled out. But yeah, final thoughts. We'll go Corbin and then Josh and then Jenin, and then I'll wrap us up.
Yeah, I think mainly just reiterating your point that we're going to be hearing more about this, to riff on the RFK thing for a moment. I think this notion of independent incentives is going to be a difficult issue. Maybe it's unavoidably difficult, but RFK kind of proves the point where if you want somebody explicitly named, I think RFK's your man, right? I think he was one of the disinformation dozen or whatever the government, like he's explicitly called out by the government. Meanwhile, and maybe this gets more to the merits, but the further out there you are, if you're RFK claiming that Hank Aaron died of the COVID vaccine when he had a stroke, or just asking questions, it's awfully suspicious, and you're going down to American Samoa and fraternizing with anti-vaccine activists 2 months before a measles outbreak. The sort of further on the spectrum to 5G causes COVID you are, the higher the platform's independent incentive. And I don't know how you deal with that. I mean, it's incredibly fact intensive. So I think we're in for a lot of, Josh is right? Like we're going to be seeing a lot more litigation about this.
Yeah, I think the one thing I would add that hasn't been discussed too much yet is, in a perfect world, it really is the social media companies who should be bringing the suit, right? Like they're the most natural ones, and yet it's very difficult for them to do that. I mean, as Justice Alito's dissent says, they're very reliant on the federal government for a whole host of things, not only diplomatic negotiations across Europe with data transfers, things of that nature, but also all these social media companies are being sued by either the FTC or the DOJ for, I shouldn't say all of them, Google and Facebook are being sued for alleged antitrust violations. And, I think if you're the general counsel of one of those organizations, you say, absolutely, we should cooperate with the federal government as much as we can. So, and maybe they'll go a little bit easier on us in those antitrust lawsuits. And so it's one of those situations where you can't really, as a social media company, you can't really take the public position that the federal government is pressuring you. It looks bad to your stockholders. It looks bad to your users. It also threatens the bottom line of your company. And so we've got the situation where we've got to figure out, okay, given that the best plaintiff isn't available, who's going to be the second best? And I think that's something that everybody across the country is going to be looking at in the future.
I just wanted to clarify, too, that when I said I thought the court was saying that might be what the court was saying, that's not what I think should be the case, in case that was misinterpreted in any way. But I think my final thought is that, the First Amendment obviously protects untrue speech. But what I think gets lost a lot in this case is that our clients, I would say, especially Jay and Martin, who are epidemiologists considered top in their field, were being censored on the areas of their expertise. Martin was censored when the government was saying, to censor anything that might cause vaccine hesitancy, was censored for a tweet that said naturally immune people don't need the vaccine. He's one of the most cited vaccine experts in the world. So what the government was doing was really stifling debate about COVID policy and other topics as well. And I think that led to the adoption of a lot of bad policies. And this case shows why we have a First Amendment, because it's a huge problem that this happened.
All right. Well, just want to thank you three for making the time, and yeah, it there will be more. Hopefully, we can do it again. And I want to thank Jenin and Josh for raising these issues, and Corbin for having the foresight to see some of the problems that the Supreme Court saw. Steve, go ahead.
Yeah, I just wanted to thank this stellar panel. Thank you to Corbin, Josh, Jenin, as well as you, Brent, and thank you to the audience for tuning in and seeing the discussion and disagreement. And for more content like this, please check out regproject.org. That's regproject.org. Thank you.